Hello everyone, it's Mark and welcome back. In this video I'm going to talk to you about Section 12 and how long you can be held versus Florida's Baker Act and how long you can be held in Florida. So under Section 12, it says here, right here, the first commitment is valid for up to 6 months. So that means any time between 0 and 6 months you can be detained. Does that mean that you could be released before 6 months? Of course, if you are no longer meet criteria, you can be released. In fact, you should be released. So it says subsequent commitments extending without break after an initial 6-month commitment are valid for 12 months. So that means that after the initial 6 months, you could be held for another 12 months. And that could be continuous. In other words, without a break, meaning it's a straight 12 months. Now, again, could you be released if you no longer meet criteria? Of course. I mean, the goal here is to get somebody stabilized so they no longer meet criteria and then get released. In Florida, under the Baker Act, which is Chapter 394, it's up to 6 months. And again, that can be extended for chunks of 6 months at a time. And the goal here, obviously, is to get somebody, stabilized and to the point where they can be released. But the problem with with Section 12 and even the Baker Act is that, frankly, once you get sucked into the state's mental health system, it can be a really tough job to get somebody out. I mean, it's been my experience that these hospitals respectfully don't do a great job in treating people. They medicate them and sometimes over-medicate them. They have an excuse to bill insurance. And frankly, if you get stuck there, it can be one hell of a job to get you out. So obviously, if it's Section 12, the best time to file to get out is in the first 3 days. Same with the Baker Act, the best time to get out is in the first 3 days. And so, yeah, look, you can be stuck there for a long, long period of time. Anyway, with that said, thanks for tuning in. See you in the next video. Bye-bye.